Morning, everyone. As already mentioned, my name is Tudor Fabian. I'm coordinating the work of SME Europe here on international trade-related issues. On behalf of our Executive Director, Dr. Heitz, and our gracious host, MEP Juliu Winkler, First Vice President of SME Europe, very happy to welcome you at yet another edition of our SME trade discussions. Today, we focus on a topic that has been receiving rather fervent interventions left and right and has been making headlines in the past couple of months, namely the EU-China Comprehensive Agreement on Investment. Now, whether you are for or against this agreement, whether we have strong opinions in either direction, we believe that this is a secondary problem when compared to enforcement and proper implementation. So indeed, there is no point to have a very good agreement if this is not properly implemented. And this is why, together with SME Europe, we thought that it is very good to have this event today. I'm very happy to welcome a stellar cast. So representing SME Europe, we have our president, Mr. Ivan Štefanec. Also representing SME Europe and our host as well, First Vice President, Mr. Juliu Winkler. From DG Trade, we have none other than Denis Redonnet, Chief Trade Enforcement Officer, someone that doesn't need an introduction in trade discussions. And then as the debate goes on, we have discussants, Mr. Christoph Hansen, who is EPP coordinator in the International Trade Committee. We have Friedolin Strack, who is the head of department for international markets at the German Confederation of German Industry. And we have Jana Hartman RADOVA, who is representing Czech industry here today and also is a permanent delegate at Business Europe. We have Francois Baur from Économie Suisse, who is head of EU affairs. And so without any further ado, I would like to pass on the floor to our president, Mr. Ivan Štefanec, for a brief introduction. You have the floor, sir.
Thank you very much, Tudor. Good morning, everybody. It's my privilege to open today's discussion on a very timely and very, very important topic on which my dear colleagues Juliu and also Christoph worked very hard and very successfully. I do believe that we need this agreement. I do believe that EU's policy towards China should be really based on the principles to cooperate where possible, compete where needed, confront where necessary. And such approach allows EU to react with flexibility to the evolution of the bilateral relationship. China is really a global power. We cannot, and we don't want to isolate, and certainly we don't want to ignore it. In terms of economical figures, we have to recognize that in 2020, China became the EU's main trade partner, surpassing the United States. As countries around the world, including in Europe, struggle to recover post-pandemic, China's economy in 2021 is expected to grow by more than 8%. And as China's role in the global economy grows, imbalances resulting from China's state-owned enterprises and industrial subsidies also, I do believe, must be corrected. Rules protecting intellectual property must be strengthened, especially with the growing importance of new technologies, particularly like artificial intelligence. And the recent conclusions of an in-principle comprehensive agreement on investments between EU and China, agreement which must be ultimately ensure fairness, reciprocity, and sustainability, and in which must include strong enforcement mechanism. Why we need this agreement? Because we have a lot of investments from the European Union, particularly German industry is the main driver, showing more than half of the investments it is done by German car industry. And also we need it as a leverage to eliminate forced labor. China's obligation under this agreement must be to have more accessible and open market, to ensure fair treatment of EU companies and a level playing field for business, eliminating discriminatory practices, liberalizing investment and preventing backslides, removing quantitative restrictions, capital ceilings and requirements. I think the three main sectors are important, like electronic vehicles, telecommunications and private hospitals, but of course we deal with all the sectors of economy as well. So in this text of comprehensive investment agreement on investment, China has made commitments on three key pillars. First, market access; second, level playing field; and third, sustainable development. To conclude this opening remark, let me highlight that I do believe that EU trade is really a very powerful tool for promoting European prosperity, interest, and values, and we have to do so. EU is the biggest trade bloc in the world, and we have to lead it based on our model of open strategic relationship, and we should lead the fight for our free and fair market that protects and promotes the European Union core democratic values. So we have the challenge here in this agreement, in the implementation of this agreement, to promote the values, but I do believe that it's possible and we are going to be successful. Thank you very much, and I'm looking forward to all the contributions and discussions.
Thank you very much, Mr. Stefanec. Very good introduction to set the scene for the rest of the speakers. Without taking up any more time, I would like to pass the floor to Mr. Denis Redonnet, who will give us a little presentation from the Chief Trade Enforcement Office. So you have the floor.
Hi. Yes, thank you very much. Good morning to everyone, and thanks very much for having me on this call and in your meeting. Very much appreciated, and appreciate to be able to engage with members and colleagues here. Look, I think I will give my perspective indeed from the implementation and enforcement point of view. It's very clear that this agreement is one of the tools in a broader strategy with respect to the economic relations with China, which is itself evidently complex, multifaceted. It's an agreement that has as a primary objective to rebalance a number of asymmetries in market access and to level the playing field. We have an interest in leveling the playing field, as just been said by Mr. Stefanec. The relationship is still unbalanced in terms of legal commitments and in terms of practice. And an agreement and its implementation addresses these different issues. Now, how is that done? Well, I think for me, in order to address the question you have put on the table today, I think one needs to look maybe at three things. First, proper implementation and enforcement of any agreement, and to be the case for CAI, will always inevitably be a function of the nature, the precision, the robustness of the actual treaty commitments themselves in the first place. Second, and there are things to say about what kind of specific commitments we have in the agreement. Second, I think implementability and enforceability of any agreement is also a function, of course, of the mechanisms that you have in the agreement itself to ensure compliance. And it's a function of the efforts that are going to be put in terms of first monitoring and then the implementation and enforcement action itself. And third, I think in particular here, implementation and enforcement of this agreement will also be a function of how the agreement itself fits within a suite of instruments that go beyond the agreement itself in terms of managing the overall relationship and how these work in sync. So on the first point, with respect to the actual underlying commitments themselves, obviously in terms of market access, as you know, the agreement would bind the unilateral openings that China has done and over the last 20 years, so it's quite significant. Would include commitments that were missing from the WTO, notably in manufacturing, and bring additional market openings in a number of sectors, cloud services, private healthcare, manufacturing electric cars. The schedules are now published. I will not go into this because this is the agreement itself, but everybody will be able to assess the value of these commitments in terms of market access in and of themselves. Second, on the level playing field, the agreement contains a number of treaty obligations relating to state-owned enterprises, forced technology transfer, and enhanced transparency rules for subsidies. All of the issues that are very specific to some of the distortions that we observe in the Chinese market, and that therefore are very important to address, and of course go beyond China's existing commitments. On state-owned enterprises, as you know, the CAI would require the SOEs that are engaged in commercial activities to act according to commercial considerations, would make sure that they do not discriminate our companies in their sales and purchases of goods and services. And in this way, CAI commitments on SOEs clarify or reinforce the existing Chinese commitments in the WTO. Clearer definitions of SOEs. Secondly, an ambiguous coverage at all levels of government and in all economic sectors of the SOE provisions. And third, in addition to the concepts of commercial considerations and non-discrimination, which are the two big treaty commitments, the CAI includes additional transparency rules, which would allow to collect information with regard to the characteristics of an enterprise and its behavior to assess precisely the compliance with the rules on SOEs, the disciplines. Now, on subsidies, say similarly, there are a number of obligations, publication obligations on subsidies in the services sector, which is a net WTO plus. That's one big deficiency, one of the big deficiencies in existing WTO rules and the commitments that China has made into the WTO. And in the area of subsidies, the CAI establishes a two-stage consultation mechanism between the parties of the treaty, allowing to collect the necessary information to assess the negative effects of a subsidy on the investment interest. And that consultation process and the obligation to share information upon request under the agreement that is negotiated applies to all subsidies affecting investment, whether it's goods or services. Again, this is a tool which in itself is an instrument that enables proper monitoring and implementation further down the road. On forced technology transfer, which is also a very important level playing field element, the CAI contains very clear rules against forced transfer of technology in terms of requirements to transfer technology to a joint venture partner, as well as prohibitions to interfere in the contractual freedom in technology licensing, for example, which are issues which we have been confronted with and have raised in our relationship with China in the past. Now, also important to say that in the level playing field area, these disciplines are subject to bilateral enforcement mechanism through, I would say, classical modern state-to-state dispute settlement processes. Third element in terms of the commitments, the Sustainable Development Chapter, which contains commitments on environment and climate as well as labor. You know that these provisions have never been negotiated before by China in any of its trade agreements and treaties. So there's evidently an element of novelty there. Commitments include and are quite far-reaching in terms of climate. They include effective implementation of the Paris Agreement. In the area of labor, China has undertaken the commitment to effectively implement the ILO convention that it has ratified and to make continued and sustained efforts to pursue ratification of the ILO fundamental conventions on forced labor. Now, in this area, I think one thing that needs to be said about the commitments is that these are commitments on core labor standards and the fundamental conventions, which are substantively identical to those that we have agreed in other agreements, including in comprehensive trade agreements. I'm thinking, for example, about our agreement with Korea. And we have, as you know, recently benefited now from, in a sense, clarification and interpretation of what these commitments actually entail, because we have undertaken a dispute on labor commitments under the agreement with Korea. And the panel of experts ruling that we have received under the dispute that we have with Korea on these matters has confirmed indeed that these commitments are legally binding and enforceable. The panel of experts in the case of Korea has also interpreted the commitment to make continued and sustained effort. And it has very clearly provided the interpretation, and that interpretation is persuasive, that this constitutes a clear legal obligations on the basis of which any party which is subject to these obligations would have to take concrete, continued steps towards ratifying the said conventions. In the case of our dispute with Korea, the panel has made a clear recommendation for Korea to complete the ratification of the conventions in question. As a matter of fact, Korea has already made a very important step as a result of this process unfolding over the last few years, and has actually ratified 3 of the 4 outstanding ILO conventions, which were at issue here in our bilateral dispute with Korea. But I will come back also just briefly to the question of the procedural framework associated with that, which is also important. Now, that therefore brings me to the question of the actual mechanisms to ensure compliance that are built in the agreement itself. Because it's evident that implementation of an agreement of this kind will be challenging. It requires, first and foremost, before I even get to the question of actioning mechanisms, it requires a serious focus and allocation of resource by the parties themselves to monitor the agreement. Now, as you know, this is an effort that we're doing not just in relation to one agreement in the future in the case of CAI, but that we're doing across the board with all of our trade agreements. It's a very clear pivot towards that effort that we're doing very consciously out of the Commission with the support of the Parliament and member states in Council. And it implies maybe 3 things, and I'll be very brief on this. I think it requires to organize, it requires to engage, and it requires to equip ourselves. Now, organize because implementation, proper implementation, and the results of what you get from it is a function of the input that you make in the first place in this effort. It is resource intensive. It requires to have expertise, capacity, people monitoring. It requires us to leverage capacity in terms of human capacity and analytical capacity about what's going on in third country jurisdictions across the Commission, beyond the DG Trade. Second, it requires to engage, and by that I mean engage with the stakeholder community. So we will need to interact intelligently when we implement an agreement like CAI with the interested stakeholders, in particular those that are present in the Chinese market, because the proper implementation will come from that effective interaction between public authorities on one hand, responsible for engaging with China under the framework of the treaty, and the input that we will get from our stakeholder community. This is why we have established a new single entry point and a mechanisms for complaint, which would apply in this particular case. And it's difficult because these agreements are any agreement, trade or investment agreement is difficult to navigate, in particular for small and medium-sized enterprises. So there will need to be a particular effort by SMEs to help them navigate the commitments under the agreement and the reality on the ground that they may be facing in the case of a jurisdiction like China. And finally, equip ourselves in the sense that it requires a number of legal instruments and statutes. I'll come to this in a minute. Now, just to say on the question of the mechanisms to ensure compliance in CAI, it includes a consultation mechanism, which is based on a regular political level oversight at vice premier level. It also includes a sort of ad hoc mechanism to allow for rapid engagement of the political levels, again at vice premier level, in case of serious or urgent issues arising at implementation stage. Now, we believe this is, well, first of all, this is innovative. We do not have that in other agreements. And it does correspond to the nature of the Chinese system and the decision-making processes that we see with that particular partner. So we have adjusted these kinds of implementation structures to the reality of the Chinese system. Second, as I mentioned, we have the provision for state-to-state dispute settlement and the provisions there, the mechanism there, the state-to-state dispute settlement chapter is equivalent to what we have in our FTAs, with the possibility to retaliate in the case of non-compliance. And under the CAI, the EU would be able to take, in the case of a dispute, retaliatory measures in derogation from our commitments made in CAI. So, for example, give us the possibility to deny market access if that came to that, if it was necessary. And the retaliatory measures can go below our commitments in the WTO, in GATS. On the sustainable development side, for that chapter, as you know, it is subject, like in our other trade agreements, to a tailored enforcement mechanism. Now, what I think is very notable here is that we have replicated in CAI, in the provisions here relating to this particular aspect, the same sort of provisions that we have in our FTA and our modern FTAs, which include in particular a high degree of transparency and participation of civil society. I'm thinking about the fact that hearings are said to be public, the possibility to submit amicus curiae briefs, the commitment that China has taken, and it is a commitment they have never taken before, to publish the panel report in this area of the panel of experts, and the consultation of civil society in the implementation of the panel report. Again, all these are features of the system that are equivalent, substantially materially equivalent to what we have, for example, in the agreement with Korea. And we have actually seen how that operates, and actually the sort of dynamic that it creates in the state-to-state interaction when we are faced with the need to review together implementation and proper compliance with an agreement. And I mentioned the elements related to transparency. They're important because those transparency provisions themselves, as I said, can also better inform our enforcement strategy and the policy responses that we give. I'm thinking in particular about the consultation processes established in the area of subsidies or state-owned enterprises. This, of course, would give us much more than the unfortunately insufficiently functioning provisions of transparency that we have together with China as WTO members in the context of the WTO. That has proved to be very insufficient to govern the relationship. It is addressed here in a different and specific way. And I'll just conclude by saying that I think it is very important to, of course, underline that the questions relating to the management of the relationship will go beyond the agreement itself and those mechanisms inside the agreement itself. The provisions for enforceability of the agreement have to be understood in context with a suite of other instruments and statutes, including in some cases autonomous instruments, legal instruments and statutes that will continue to operate with respect to the overall relationship with China. I think there may be four things there very quickly that need to be highlighted, or four categories of instruments that play a role and that interlink with an agreement such as CAI. First would be the different instruments and statutes that exist or will be put in place, which have to do with the way in which the EU in economic relationships projects its value. I'm thinking here about, for example, the new EU global human rights sanctions regime that was adopted in December. And as you know, there will be a very important proposal by the Commission with respect to due diligence requirements for EU businesses, which obviously have a direct bearing on how the economic relationship operates. We have a number of tools in the economic area to protect, I would say, our European security as well. And they apply and continue to apply in the context of the relationship. I'm thinking about the EU investment screening mechanism or the modernization of our export control regimes. Now, these instruments are entirely left untouched by our commitments under the CAI. We have maintained the policy space to use these instruments as instruments where necessary of rebalancing of the situation that may be created with China. Third block is addressing further beyond CAI some of the economic distortions created by China, not just on the Chinese market, but beyond, in particular in our own market. And there, the instrument on the impact of foreign subsidies on the internal market, which will be the subject of a Commission legislative proposal towards Parliament and Council very soon, will be a very important part of that toolbox. And finally, there's still, above and beyond the KAI commitments, the need to inject a greater level of reciprocity with China in terms of some areas of market access which are not covered here. And there, in this context, the proposed international procurement instrument, which is currently in front of the co-legislators, remains very important in terms of completing the policy mix. So, I'll finish with this, just again to say, can China be absorbed and react and interact with us in the context of this kind of investment and trade-related treaty framework? I think the answer is yes, but it depends on two things. It depends on the design of the commitments and the enforceability mechanisms themselves. And then, of course, it will depend very much on our capacity to action these provisions once the agreement is in place, and that's a function of political commitment to proper implementation and resource effort towards proper implementation. All this has got to work in sync in order to ensure proper implementation and enforcement of an agreement of this kind. Thank you very much.
All right, Mr. Radonnet, thank you very much for that indeed comprehensive overview. You've taken us through various bits and pieces of the agreement, including some of the commitments, which I think is very important for our listeners to hear, not only on market access, but also level playing field, some of the structural issues we had in terms of technology transfers, subsidies and distorting practices, SOE disciplines and such. And then, of course, it's very good that you touched upon the sustainable development bit as well, which, as all of you all know, has stirred up quite a bit of discussion in Brussels recently. I think it was useful that you confirmed the legal interpretation of the phrase "continued and sustained efforts" based on the case study of the Korea agreement. This is an important mentioning. And then, of course, yes, for the mechanisms of compliance, I jotted down here: organize, engage, equip. Very, very important. Indeed, as you could see, already some questions are popping up, and for SMEs, this is important to discuss these issues. This is precisely why we have this event today. And then thank you again for mentioning that KAI is not the EU-China policy, but just one part of it, and that the toolbox is much larger. Now, the way we envisage the meeting going forward is to give around 5 minutes to our next 4 discussants. We would be happy to have also some dynamic interactions with Mr. Radonnet here, and then maybe we have a second round also with the Q&A from the participants. Now, I don't want to bore you anymore. We would like to pass the floor then to Mr. Christoph Hansen, the coordinator in the INTA committee, to pass on his views. Thank you, Christoph, for joining.
Yes, thank you very much, Tudor. And first of all, I would like to thank SME Europe for organizing this meeting, because it's a very timely meeting, since we are now having the schedule of work as well available. So I think that is very well chosen. And of course, I think that is a file that will occupy us over the next months, and I would even say that it goes into next year, because of course, as you know, a lot has to be discussed. A lot of opposition came already up in the very first moments, well, mainly by people that are not exactly reading things, they are just shouting out. So I think it's really that important that we now take our proper time to discuss everything in detail, and not just judge before having the overall information on the file. And then, of course, it is difficult to speak after Monsieur Redonnet, who has been called by Bernd Lange, the INTA chair, Mr. Superman. So he has already covered a lot of issues, but nonetheless, I think that the implementation of the KAI is extremely important as well for my political group, the EPP, because industry has been very clear that the KAI cannot mean that the EU cements legal access to its already very open market, whereas the Chinese side only pays lip service to their commitment. So very often there is a discrepancy between what Beijing says and what happens on the ground in the provinces, and there are many ways to pass on messages that do not seem to be sanctioned by the central government. And therefore, implementation and enforcement of this deal will be key, Monsieur Redonnet, because, well, that is your main task. And for my group, this means, among others, that we will need to continue working on the flanking measures. The other tools in our China policy toolbox, many people always say, well, this the KAI doesn't solve this, doesn't solve that. Well, that is right, but it is one part of our China policy and far from being everything in the toolbox. And so there are the autonomous measures, and some have already been mentioned. So the international procurement instrument, where we have as well pushed as EPP to have now a discussion in this week's INTA committee meeting on that, on the file, to attempt the unblocking of this file. And as you know, this has already probably one of the files that has been longest being blocked by the Council when it comes to our INTA files. And I think that is very important that there will be new momentum there. And I hear from the Portuguese presidency that they will bring some dynamism into this one. And this is, of course, a very important flanking measures for us. And then, of course, the instrument against foreign subsidies should also be a game changer in terms of leveling the playing field. Then there is as well the due diligence legislation coming down its way, where the legislative proposals will be out probably before summer. Of course, there is, and as you know, we had a vote last week in the plenary on that. But I believe much remains to be done there in terms of clearly defining the scope and the application of the law, and notably as well with regards to SMEs. And I think you are well aware of that. So there is, I think, a lot of work that we need as well to do with the Commission to have a reasonable approach when it comes to due diligence. But nonetheless, I think this will be important as well as a flanking measure. And then, of course, it has been mentioned as well by Mr. Redonnet, we need a credible human rights sanctions regime. And here, of course, it is up to the High Representative Borrell to lead and the member states to agree by unanimity. And we will see if they can get their act together. And it has already proven sufficiently difficult to get the first people listed. And we will be watching this very closely. But of course, this would be helpful that such a list would be up and running before we give consent. And then I of course, here I just read an article from where the Chinese ambassador to the EU has been quoted, where he is very unhappy about the European side pushing so hard for having these human rights sanctions in place. But nonetheless, I think this is will be of utmost importance to get a majority here in the European Parliament for that. And then at multi and plurilateral level, of course, the tripartite work on harmful industrial subsidies at the WTO, together with the US and Japan, needs to be accelerated. I think that is very clear as well, that we get on board with these two important partners and face the common challenges that we are facing. And then, of course, all of these work streams, apart from the actual implementation of KAI, will, of course, require coordination. And while we fully endorse, of course, the work of the Chief Trade Enforcement Officer, the Superman, as Mr. Lange calls him, we can't expect that you will solve all the issues. And I think, therefore, it is a very strong request from my group as well to put in place a real, fully fledged China task force, which could be, let's say, the blueprint could be the UK task force that has been led by Michel Barnier. We mentioned this as well during the last inter-committee meeting when we were talking as well about the trade policy review. There was some reluctancy from the Commission side saying, well, we can't do this for every country. well, I agree, we don't have to do it for every single country in the world, but probably for China, it would definitely make sense, because we way too often speak with 27 different languages, and this is not helping us when we have someone, a giant on the other side, that is trying to divide to rule better. And this is something we should take on board. And I think that is as well a very strong message that we have to convey to the Commission. They are reluctant, but nonetheless, I think this would make sense. I will stop here because Jeremy has already covered a lot of the points, and I'm looking forward to the exchanges. And I have just to apologize because I have another EPP internal working group on Mercosur, which is an important file as well afterwards taking place, where we have the 4 ambassadors there as well. So I will stay in the meeting for some more minutes, but then I will have to leave. And thank you very much, and I'm looking forward to the exchanges.
Thank you very much, Mr. Hansen. Those very good political messages, and we like that you brought in some bubble talk with with Mr. Superman here. So indeed, mentioned very well the discrepancy between rhetoric and action, which comes out of China. Therefore, we need to be, extra attentive to a lot of things. You mentioned the flanking measures. I thought it was interesting that there was a complete reversal of the order. So you started up with the IPI, which shows that there are clearly high degrees of expectations from the European Parliament side on this. International engagement, very important. Our alliance with the US and Japan, working on some of the structural issues, very good. You repeated a key point for the EPP, which is the China task force, which yes, if Mr. Redonnet can comment later on, we would be very thankful. And then yes, you seem to be having a good morning because you jump from one controversial topic to the other. So good luck in your next meeting with Mercosur, and thanks very much for joining us. Now, next up, we're very happy to hear from the Confederation of German Industry, Mr. Friedolin Strack. You have the floor, sir.
Thank you, Tudor Fabian, and thanks a lot to SME Europe and the EPP for this joint venture event. And Mr. Redonnet, thank you as well, and the Commission for the work you are doing for business in China. And I would like to include the superwoman Maria Martin-Pratt in the line, because she has done a tremendous job in accomplishing where we stand now with the CAI. Since we start with a series of 3 business interventions now, and I'm the first, I cover part of the business issues, and Jana and Francois will jump in with other business issues. So I will start with some general remarks. The first general remark is that if we look at China, the balancing act doing China business is getting more and more difficult from year to year. And the balancing act meaning China is one of the number 3 markets in the world, together with the European internal market and the US market. And it's growing rapidly. So if we ask our business, our companies, large and SME, where do you see growth? Then they first point at China. Second, they point to United States, and they would wish to see more growth in Europe, but it's not taking place at the moment. So if we look at the balances, revenues, turnover of German companies in their 2020 balances, China has been an anchor of stability, of maintaining growth at a very high level. So we need to take this into consideration. But at the same time, we see more and more political issues popping into business. We are very concerned on what happens in Hong Kong. We are very concerned on what happens in Xinjiang. We know the discussion on Xinjiang will drive us deep into a discussion on what business is possible in China. Is Olympics participation possible in China? So there is a lot coming up in issues related to China, and I must clearly say related to doing business with China. The times of naive business in China and with China, they are definitely over, but still we must be clear, it's one of the #1 markets of European industry. Second point is, while in the past we have been bothered mostly by formal market barrier entries, our focus has shifted a lot to informal market barrier entries, and Denis Redonnet, this is definitely one of the focal point for implementation, because it's much easier to tackle formal market entry barriers vis-a-vis informal market entry barriers. And we had hoped that CAI would be a step in bringing China towards more market rules, and definitely this has not happened, and our expectations have been too high. The wish list was too long, but nevertheless, these are core issues that we need to tackle. Third point is that we should not forget that a lot of companies, and I can specifically refer to a lot of German medium-sized companies, they face no market barriers in China. I would guess 80% of German companies doing business in China, they find a good market. They have neither formal nor informal market barriers. If you look at automotive supply industry of Germany, having invested in China, they are quite happy in this market. And we are worried about a lot of issues mentioned, also mentioned in the chat already, cybersecurity law, social credit system, but business is going quite well for the majority of companies. Also, we should not forget that. When I look at CAI, this is my fourth point, then clearly we see my top 3 points in CAI. We see little actual market opening in manufacturing industry, but that probably is not the measure that we should take. My top 3 in CAI is first, we have equal access to Chinese standardization bodies. That is my #1, because that is really important. And if I look at the China Standards 2035 strategy, this is an asset, and we are thankful for the Commission that they have pushed this point through. Second, and Monsieur Redonnet, you mentioned this, the commitment of no compulsory technology transfer is an excellent commitment. And we had this commitment by Chinese government before, but we did not have it in a treaty. And it is really important. And third is probably the Chinese commitment in a sustainability chapter overall on climate, on labor rights. They are important. This is important topics for business, and I would count that as #3. If I look at the total assessment, then I must say and refer my 5th point to RCEP and see how do competitors of European industry act in the region. How does Japan act? How does Australia act? They proceed, they take what's on the table, and we should do the same. We should take what's on the table and fit it into a smart China policy that the Commission came up with in March 2019 in a very clear and precise China communication that I find is one of the best China communications and China strategies I've seen from all around China policy strategies from all around the globe. Probably with the exception of the Australians, they really dared to do a shift. My final point, what really matters is the strategy ahead. And there is a lot we need to do. First, we have the open package of investment protection. This is important. We need a second, we need a CAI phase 2 with investment protection, definitely. with investor to state dispute settlement in one or the other form, we need to agree with the Chinese on this package. Second, implementation is really important. And for implementation, we need to take into consideration that China is special. And it's always difficult for European business to point at difficulties in China, knowing the Chinese potential for retaliation is immense. Why is that? Because of the state interference in everything in China. And this is the core problem in the Chinese market. It's the state-led economy, the party-led economy, this hybrid economy that makes our business difficult when we look at China. We also need to demand further market access from China. We have reached a certain step, but we need further steps. We should make clear at every occasion, and we in BDI, we try to do that as well, and accompany the political work, that we do not leave China in this position of feeling comfortable in the role of a state, of a party-driven economy. We want market reform in China, and the small steps we have in CAI towards anti-subsidy, towards market behavior of SOEs, they are good. We don't believe in immediate success, but we together must address these issues. And last point, I'm fully with Monsieur Redonnet that we need to look at European instruments to level the playing field. The white paper on anti-subsidy is important. The IPI is important. I advocate for stronger European investment screening. It's too national until today. I know that all the countries, including Germany, they do not want Brussels to take a role in actual investment screening beyond coordinating. I would advocate, if we want to play a role vis-à-vis China, it must be an EU role and not a German and a French role. And last not least, I see a clear opportunity for more international cooperation on the resilience issues together with the US and the Biden administration. And we should not forget that after Trump left office, this is a huge opportunity for us. Thank you.
Mr. Strack, thank you very much for that sober analysis, and also in the beginning giving credit where credit is due. Indeed, Madame Prat has been a superwoman going on to all these events, and she has, this is a full-time job basically, just engaging on CAI discussions. Now, you mentioned a lot of important points, not only discussing the economic factors in China, but some of the expectations in terms of market dynamics. The issue of standardization, we think this is really, really important, particularly China Standards 2035 as the upcoming strategy after China Manufacturing 2025. This normative battleground is definitely a place where the EU should be taking an active role. Treaty commitments, it is important to have these commitments enshrined in the treaty in a binding agreement, written black and white. This gives us more power and also gives, we believe, more continuity and legal certainty for our businesses and SMEs. You mentioned global dynamics with RCEP and the regional trade architecture. This is very important to put things into context. And then for strategy ahead, yes, investment protection. This is something that we will continue to be pushing Commission on an opinion here. Sober analysis on the role of the state in the Chinese economy. And then, yes, this push for investment screening, this might be interesting to also be flagged in Berlin and in other capitals, but it's very good to hear this in Brussels as well. Now, going up next, and we understand that Mr. Stefanitz, our president, has to leave for another meeting. Thank you very much, sir, for taking the time this morning. Now, going next, we have a representative from the Czech industry, Madame Hartman RADOVA. Jana, you have the floor.
Thank you very much for the floor and also for inviting me to this timely and very important discussion about the CAI agreement and its enforcement, because indeed the implementation and enforcement of this agreement will be crucial. And from this point of view, I also very much appreciate the presence of Mr. Redone. A lot has been said, so I will try to be brief and focus on how we see this agreement. We welcome this agreement and I will explain why. We actually see it as a good step in the right direction and also a key component of EU's broader strategy, which is aimed at rebalancing the relationship with China, which is in the interest of us all. China is a very important market. There are Czech companies which have succeeded on the Chinese market, and this agreement can help improve conditions for those doing business in China, but also help those which want to enter the market. From our point of view, it is rather an ambitious investment agreement, and here I would like to highlight the word investment. As we heard from Mr. Redone, it contains many legally binding conditions and unprecedented commitments from China in various areas. And from this point of view, it can add legal certainty, transparency, and also help level the playing field for European companies, not only vis-a-vis Chinese companies, but also with regards to companies from other third countries, which already have an agreement with China. Because as we all know, the EU is one of the last major countries without any agreements with China, and it is right about time to actually balance this situation. Regarding the content of the agreement, of course, it is rather too early to give you some complex and proper evaluation and opinion. We still need time to analyze the text and also the schedules which have been released recently. Now there is this process which is going on, and it can also lead to some changes in the text. And a lot will depend on its implementation and enforcement and other factors. Also reacting to some comments, of course, each agreement can be more ambitious, but I think that in each negotiation, we must try to negotiate as much as possible with that particular partner in that particular moment. And I think that here we need to be rather reasonable and pragmatic, and also acknowledge that this agreement opens the door for future dialogue and future negotiations. As I agree that this shouldn't be seen as a standalone agreement, but rather part of EU toolbox, which it already has or will soon have at its disposal, but a very important part. And in this regard, I think that the EU should cooperate with like-minded countries, including the US, and it should work together with them and pursue coordinated actions where possible. And the second, of course, there are also those autonomous instruments. But here I would already like to emphasize that these instruments need to be compatible to each other and complementary with each other. And they must be established in a way that they are effective in practice and they do not add additional disproportionate burdens on EU companies. We have also heard a lot about the monitoring and enforcement mechanisms, which are actually part of this agreement. No need to go into detail here, but I would like to highlight that we think that, for example, this institutional oversight at high political level, which also enables ad hoc meetings to deal with urgent matters, could be very useful in the practice. What are we actually missing in this agreement? Here I would also mention the investment protection part and the investor to state dispute settlement mechanisms. Of course, this is very important for businesses, and indeed there is a gap which needs to be filled. But what is good that both sides committed to pursue negotiations within 2 years of the signature of the agreement. So although our wish list isn't entirely empty at this moment, our initial view is that we are positive about this agreement because it can bring some real improvements in key and also new areas. And before concluding, I would also like to mention one thing, and this is that the EU cannot only negotiate agreements, but it also needs to be able to conclude them and ratify them. So it will be no surprise when I conclude with saying that we hope that this agreement will be ratified as soon as possible and that this momentum will be used. Thank you.
All right, Ms. Hartman-Radova, thank you very much. Very thorough analysis. You mentioned very good points on the rebalancing of the international relationship in terms of the EU also having an agreement with China on economic matters. The fact that the agreement brings benefits not only to companies that are already present on the Chinese market, but also for companies that wish to enter the Chinese market. This is an important element. The like-minded cooperation has been echoed as with the other speakers, having mentioned the US and Japan. The complementarity of the toolbox is indeed very important. So we make sure that there's no duplication, and at the same time that there's no increasing negative impact on our companies and SMEs. Investment protection. So one more point for the EU Commission on this. Investment protection is very important for companies, and the fact that, yes, in order to maintain credibility, the EU also needs to conclude agreements, not only negotiate them. We have our next intervention from Francois Baur from Economy Suisse, a very interesting case study from a country that, even though not an EU member state per se, it's a semi-member state that already has some agreements with China. So your experience will be very valuable for our discussion today. So please, sir, you have the floor.
Thank you so much for the opportunity to participate in this distinguished panel to talk about the experiences we had within the relations with China. So I give you a flavor of the bilateral relations, and let me remind you that Switzerland has been one of the first Western countries to recognize the Chinese Republic, and the two countries celebrated in 2020, so last year, its 70th century anniversary of diplomatic relations. And in 2009, the two countries signed the Investment Protection Agreement, which entered into force in April 2010, so already 11 years old. The agreement is quite standard and straightforward. It only includes rules on investment protection and on reimbursement in case of expropriation, as well as the dispute settlement procedure. It's only 12 articles long and is complemented by a short protocol with 5 more provisions, so very short. All other trade issues are covered by a free trade agreement between Switzerland and China, which entered into force in 2014. This agreement contains provisions on trade in goods and services, non-tariff barriers to trade, intellectual property protection, was quite important for us, and sustainable trade and development. By the way, somebody has asked whether about the intellectual property protection, that Chinese courts are claiming their only responsibility for that. For the time being, we haven't had any issues with it. We'll follow this closely, but so far we haven't received any negative replies from our companies in this, and we have a high stake, specifically in pharmaceuticals, for instance. Actually, an update of this free trade agreement is already pending and was also on the agenda in 2017, but as little has happened since then, due to the fact that transitional provisions on gradual reduction of tariffs over time are still in force. The intention is to wait for the full effects before the two countries commit to further tariff reductions. The two agreements have been very beneficial for Swiss business so far, and bilateral trade between Switzerland and China has increased significantly in recent years. Switzerland exported goods worth 12 billion euros to China in 2019, up 10% of the previous year. Imports from China have been climbing by an average of 11% per year over the past 10 years, and most recently stood at 13.5 billion euros. So quite a balanced trade result. This trade amounts to 6% of the total trade of Switzerland, which is still lightweight with regard to the trade between Switzerland and the EU, 27. which amounts to 55% of the total Swiss trade. And on the other side, let's recall that trade goods between China and the EU amounts to 16, if not more now, of total EU trade. As we have heard, Chinese trade has now surpassed the one with the US. To be more specific on the benefits of the investment protection agreement, Swiss banks, UBS and Credit Suisse, for example, were able to acquire majority stakes in Chinese subsidiaries early as a result of this. And just last September, Winterthur-based piston processor specialist Burkhardt Compression, who is a leader in compressors for the gas and oil industry, acquired the remaining 40% of its Chinese subsidiary, Shenyang Yuanda, in which it had held a 60% stake since 2016. The Chinese offshoot employs 650 people, 100% subsidiaries have so far been the exception rather than the rule. But the EU-China tie is also good news for Swiss companies. For instance, the agreement talks about companies' access to the market for Chinese cloud services. Entering the market for data services could also be interesting for Swiss companies. Here, at best, the Swiss IPA could be supplemented. Switzerland's IPA with China also contains a most favored nation clause if China were to accept new rules from the EU against the forced transfer of technologies that go beyond what is in the Swiss IPA or in the Swiss Free Trade Agreement. It would be possible to insist on equal treatment. Additionally, if companies from the EU were now to invest more in China, this would also have an indirect positive effect for Swiss exporters, Swiss suppliers to the German automotive industry come to mind, for example. However, the bilateral relationship in commercial transactions is not always harmonious. There have been cases, for example, in which know-how from Swiss subsidiaries have been copied despite the IPA. And so far, however, China has always honored its obligation and always settled matters before a case would be brought to the dispute panel. Beijing, on the other hand, is likely to be annoyed now by the fact that in March 2020, the Swiss parliament instructed the federal government to introduce a law on investment control, which is not called Lex China for nothing. Business is not in favor of this law because we think that strategic infrastructures in Switzerland are already well protected from foreign control, and more is not necessary. Let me perhaps say that we have, when the free trade agreement was in place, made a single interest point of our federation for SMEs to come up with any questions they might have to apply the free trade agreement in their business cases. And then we connected ourselves directly with the Secretariat of Economy. A good thing about a small country is that everybody knows each other, and it's easy to come up with practical solutions for the issues. There were issues, but we were able, and very often the issues were also with regard to the largeness of China. Many authorities did not know of the free trade agreement or the IPA, were not aware of the implications, and we had to go through the Ministry of Commerce to instruct them correctly on how to handle Swiss businesses. And this has been proven quite successful. I stop here and I'm available for any questions you might have.
Thank you for that, Mr. Baur. Very, very, very good stuff on Switzerland, and we're always happy to hear the pragmatic approach and the robust defense of business and economic interests on global level. Indeed, interesting to hear that your FTA also has sustainable development clauses or commitments. Maybe you can expand on this a little bit later on. But for now, maybe we would close the first round here, and I would be happy to pass the floor back to Mr. Redonnet for any kinds of reactions to what our discussants have said. We've also received, if I'm not mistaken, a couple of questions. I will try to read out now one of them from Erika Ebers from Weber Schandwick. Looking into the EU-China Comprehensive Agreement and the differences in the regulatory approaches to technologies between both sides of the agreement, how would the EU position itself to ensure competitiveness in the digital sector? So now, Mr. Redone, I don't know if this is something particularly for you, but maybe you can give us a hint also on the China task force. And if I may abuse my my role as a moderator, maybe a couple of thoughts on the access to markets application. This would be very interesting for our SMEs to know more about and to hear from you. So yeah, the floor.
Okay, well, there are many things there. I'm happy to cover maybe some of them, or I'll come back later on, reacting to others. There were a lot of very important, interesting points made here. I just maybe want to come back to a few things. I think there were a lot of interventions which I thought were very interesting in the sense of, you know, we have from the business community side, there's a long wish list, and that wish list is not entirely satisfied by the conclusion of a single investment agreement. And I think that's the key point. It has to be seen as one building block of something that has to be much more comprehensive if the leveling of the playing field is to take place effectively with China. I think that there was one point in particular that was raised in this context, which I had not addressed initially, which is the cooperation with like-minded countries. That is indeed very important. I think that our ability to govern our overall economic relations with China depends on our ability to negotiate specific commitments and implement them effectively when we have a vehicle like KAI. We talked about this. Evidently, it will also relate to our ability to continue to develop the global rule book, which applies to all WTO members, including China, because there are things which go deep into the core level playing field questions, which inevitably cannot be dealt with in a bilateral and preferential setting. There are things which really are global level playing field issues that only global rules can ultimately and sustainability address. So that's why for us, there is a continuum between the efforts that Maria Martin Pratt and the negotiating team have made to reach an outcome on the KAI, and the efforts the Commission is proposing to continue to make in reforming the global trade rule book through reforming the WTO. That in itself requires engagement with like-minded countries in building that effort. And there in particular, I took good notes of the calls to resume and reactivate, for example, the trilateral engagement between the EU, the US, and Japan, when it comes to going further in terms of developing disciplines, for example, in the area of subsidies, but also possibly SOE disciplines, and I would say a range of competitive neutrality related issues. So we see this very much working in tandem and working in sync, and we look forward to that kind of engagement. On the question of whether there is discrepancy between rhetoric and action, again, it's linked to that. I think that we must separate different issues. It is correct that the overall level playing field disciplines are insufficient today in the WTO, in particular when it comes to behind the border type regulatory issues that affect trade and investment. And in a way, where we believe that where China has taken very concrete, precise, verifiable commitments, for example, in the context of a WTO accession, by and large, its track record of compliance with its commitments has actually been, I would say, acceptable. I mean, everybody has difficulty to comply, and from time to time with its, commitments under international economic law, it's normal. The Chinese track record, where there are very explicit commitments that they have taken, in particular in the context of their accession protocol, has been, I would say, acceptable. We have had disputes, and where we have had disputes, China has put itself into compliance. China has also, by the way, engaged with us in the multi-party interim arrangement, which enables us to properly adjudicate through third-party adjudication a dispute that we would have with respect to China's compliance with its WTO commitments. This is a very important part of the enforceability, our ability to have enforceability vis-a-vis China. So that's there. But it is correct also that the Chinese economic system has benefited from the insufficiencies of the rule book. And where the rule book has been insufficient, it has found a way to morph itself into the different holes and cracks of the WTO rule book as it exists today. That's why that effort at reform going beyond CAI is very important. And there's a much more practical aspect. Your point on SMEs, I was very interested to hear the Swiss experience there, where indeed we will need to continue to make a specific effort to help SMEs navigate these relationships, in particular when they are trying to have market access in jurisdictions which, in terms of regulatory transparency, are perhaps less efficient than the one that we have in the EU. There, public authorities need to provide support and tools, both support and tools. And in this case of SMEs, we indeed place a lot of focus on some of the, let's say, operational tools such as access to market, which is a web portal which really helps enterprises, and in particular SMEs, navigate the complexities of market access in third countries and the complexities of having recourse to our trade agreements. In order to make that even more efficient, we are very much looking forward to work, I would say, directly with SMEs in particular, in order to help them provide us with the information that we need to be able to act. And so under our new single entry point for complaints in terms of compliance with with the commitments on trade agreements, we want to dedicate effort in engaging directly with SMEs in particular, even at pre-complaint stage, to make sure that we give them the necessary support to have access to this mechanism. So I think there's a whole accompanying effort there that is resource consuming, but that we understand is necessary because the formal means of redress will of course be more difficult to access for smaller firms than for larger firms. And even the information about trade agreements and the commitments that they can benefit from will be more difficult to access for small firms than for large firms. And there needs to be an effort at compensating this through a range of means by the public authorities. And that is both Commission, but also member states' assets and capacities. Very important that we work on these matters of implementation and enforcement in close partnership, in particular with member states, be it through the coordination mechanisms that we have about that market access partnership in the EU, but also very much on the ground in the third countries themselves, where we've got to pool our diplomatic assets, both from the member states and from the European Union institutions together. So I think these things I think are also important to highlight because I think they correspond to some of the points, the concerns, the real life issues that have been flagged here in the interventions. Thanks.
Thank you very much, Mr. Redonnet. Tremendous job in covering a very wide pool of issues. Once again, global rulebook, incredibly important, WTO level. Thank you for mentioning that as well. And then yes, this catchphrase of competitive neutrality, which it has its ups and downs. Access to markets very important for SMEs, and indeed, generally speaking, access to information is very important, particularly when one has a smaller team. It is good to be able to go through all the different requirements. Now, going forward, I do not see many other questions. I see Mr. Strack. If you want to, you can directly take the floor, sir. Maybe we have another 7 to 8 minutes.
Okay, a quick question to Denis Redonnet. If I look at China's track record in implementing promises, then I have two examples where I find what has been delivered quite weak, and I would dare to say this relates to issues where China would have needed to change the system and get more market into the system. One example is government procurement. We have this old commitment of China in the accession protocols with the US and EU to sign the government procurement agreement of the WTO, and all the offers of China have not been satisfactory until today. The second example is the OECD Global Forum on Access Capacities in Steel and Aluminum, where China promised to come up with all kinds of information on overcapacities in its sectors. And what I hear from the relevant industry in Germany, ThyssenKrupp and others, they do not really see that China lived up to the promise of transparency in this forum. So my question would be, how can we tackle the more systemic issues in the CAI, especially SOE market behavior, which is quite a vague definition, and the subsidy where China committed only in services. And of course, we would like to tackle subsidy in industry as well, and not only in services. Thank you.
Thank you very much, Mr. Strack. If we may just add the second part of a question that was posted in the Q&A, that Chinese courts have very recently claimed exclusive jurisdiction over the intellectual property of European and US tech companies. In your opinion, is the extraterritorial nature of these recent court orders compatible with the letter and spirit of the CAI? Maybe Mr. Redonnet, you can also briefly react to this one. The floor is yours.
Sure. Just so a few thoughts on the first point. But I think what you say, I think to me suggests that it is indeed very important not to rely only on promises of a political nature, but also on legal commitments under treaty frameworks. And there is a big difference. I think where China is undertaking clear legal commitments, we have to work to make sure that these are complied with, and we have to give ourselves the means to ensure that they are complied with. But that already gives us a much stronger basis than if we have insufficiently robust or best endeavor political type commitments, which are much more difficult, of course, to ensure the implementation with under economic and trade agreements and economic and trade frameworks. Obviously, CAI cannot in and of itself, I think, govern the direction of economic reform in China. It does not have that capacity. What it can do is it can address a number of very specific distortions that we have observed in the Chinese market in particular, and that we try to really design clear provisions about in order to balance out these practices and eliminate them. It's true that CAI similarly does not deal or address the question of government procurement. It was never meant to include commitments on market access for public procurement. I mean, these are things that these are the sort of obligations that we include in full free trade agreements in exchange of binding the access to public procurement also on our side, which is something we're not ready to do at this stage vis-a-vis China. So there's indeed an ongoing negotiation, which has been very protracted, as you say, in the context of the WTO, where indeed the offer by China needs to be further improved. And at the same time, we mentioned, I think, the necessary for the international procurement instrument to come onto the books in order to give leverage to the EU to negotiate better market access, generally speaking, with third countries to procurement markets. On excess capacity, it basically shows that this is a core structural problem that one needs to address at source. We have, by the way, and will continue to operate trade protection instruments, trade contingency instruments, in the sense of anti-dumping, countervailing duties. But again, that deals with the problem at the border. It's very clear that we need to do more work in order to address some of these structural distortions at source, to remove the source of the distortion by negotiating international disciplines. And there, of course, the disciplines that we have been incubating in a way in the trilateral process are exactly designed to address these kinds of issues. It's very clear that there's a direct link between the particular types of industrial subsidization that we see in the Chinese context and the generation of overcapacity. At least that is our view. And that, at the end of the day, remains the real way to deal with this question. If we want to deal again with this in a fundamental, structural, and durable manner. Generally speaking, on the question of extraterritoriality, I'm not going to comment specifically on the point here, but we are concerned about the extraterritorial use of economic instruments and policies and how that affects the EU. And by the way, this is not something that is specific to the Chinese context. So on this, I think it's very clear that we see that the extraterritorial application of a number of trade-related instruments is increasing. We are giving ourselves the means to deal with this, either by reinforcing, in a way, ourselves, the internal market, the euro, our capacity to take, for example, the area export controls, autonomous controls at EU level, but also, if and where necessary, we will equip ourselves with the instrument necessary to deal with any attempt at economic coercion on the policies of the EU and its member states. And on this, the European Commission will bring forward, before the end of the year, a proposal for a legislative instrument which will be geared at countering any risk, any pressure for, let's say, economic coercion. Extraterritoriality could be viewed as an attempt at interference in the internal affairs and the policies of the EU and the member states if it is abused in terms of the way the instruments are operated by a third country. So that is also clearly part of the reinforcement of the toolbox, I would say, overall. And it is evidently something that is today relevant vis-à-vis some of our big trading partners.
Thank you very much for that, Mr. Redonnet. Indeed, fascinating, multifaceted approach. I would like to pass the floor now to Mr. Yili Vlinkler, who is not only our host here today, but also Vice Chair of the International Trade Committee and Standing Rapporteur for China in the International Trade Committee. So most probably future Rapporteur on the investment agreement. So, sir, you have the upcoming minutes to concluding remarks.
Well, thank you very much. Thank you very much, Tudor. I would like, an intense 1.5 hours, I would say. And thank you very much for this. I would like to thank, on behalf of SME Europe of the European People's Party, I would like to thank to all participants. First of all, of course, thank you to all the panelists for giving very condensed, very intense and very clear views, I would say, which we could hear. Thank you for all the participants and the questions, and I think it's very important. Probably for myself also, I have taken lots of notes, but probably I will need to re-listen or review some of the interventions from the panelists, because I think that there are so many good formulations, so many good interventions, and so many information. So I have already one conclusion for this meeting today on behalf of the SME Europe. Our president, Mr. Stefanec, had to leave, but I think that in this year, 2021, we have to organize China series, because we have to continue this scrutiny of what is the content of the investment agreement with China. And Denis Redonnet, thank you very much for giving all those insights. And those are very, very important. I hope that we could also give you some elements to fulfill and complete your image about what European industries, and especially the small and medium enterprise, are thinking and experiencing of the future investment agreement. I hope that this covers your definition, Mr. Redonnet, of well-spent time, because you can leave with some feedback from European industries. And so then, if we had the Superman, Denis Redonnet, then probably for our next meeting, we will invite the Superwoman, Martin Maria Prat. And I already, to the participants, I can make this announcement. In future, our next event will concentrate also on content and on elements for market access and commitments made by China, because those are very complex, as we could hear from the German industry and German and Czech and the Swiss industry. Of course, the wish list was much longer, and this is just natural that industry has a long wish list, but still content is there. So we will continue this. Now, for the EPP group, very briefly, we are the group in the European Parliament supporting investment and supporting trade. And why are we doing this? Because we see now, even more than usually, that the European economies or the European markets need jobs. It's jobs, jobs, jobs that we need now, and trade can contribute to job creation, and jobs coming from trade are giving more added value, and also usually, you know very well, are maybe higher paid jobs than the average jobs in the European Union. But also the same EPP group is a community built on the European founding values. So we will always be in a very clever and very attentive balance between interests and values of the European Union. So I think, and I quote now Mr. Strack, I hope you will allow me this also in future, the time for naive business with China are definitely over. But still, economic and trade realities indicate clearly to us that China is such a such an important market for the European Union industries and for EU companies in generally, that it cannot be ignored. So what is our paradigm? And thank you for the European Commission. I'm also of the opinion that this is a good approach, and is also the approach of EPP: cooperate, compete, or confront, whenever it's necessary to have one or other of the attitudes. Today, what we discussed, of course, mainly about cooperation, and what we could hear is that European industries welcome the investment agreement. If it would have been more, then it would have been better, but that is a very important signal for us and for me also as the standing rapporteur on China in the European Parliament. Just very briefly about the time frame, not for the panelists, but for the participants maybe. Now we have all the elements published by the European Commission, also the text of the investment agreement, but also the market access annexes. We have to scrutinize those, and then in the meantime, the European Commission services have to make the translation of the text into the 24 European official languages. This will take up, probably together with other preparatory and technical work, something like the next 6 or 7 or 8 months. So by the end of the year, we can expect in the European Parliament and the Council the official presentation of the CAI for the ratification debate. So probably we are now in March 17, so probably in 1 year time from now, we will have something like a vote in the International Trade Committee of the European Parliament, and then, of course, in the plenary of the European Parliament. So plenty of time, and very important, and I noted this also, already industry are speaking about KAI phase 2, which is very important. So also there is the need of an investment dispute settlement system, which will not include ISDS, because we know already that ISDS is something that is not agreed by the European Parliament. It is the discussion about the investment court system, and currently, of course, those discussions are quite difficult with China, so they are also on the framework umbrella of the UN, the UNCITRAL discussions, and those will take some time. Officially, it would be up to 2 years after the official conclusion, so after the ratification of the investment agreement. And one more thing, one more element, it was not mentioned, but I would like to bring it in now towards the end of my intervention. Currently, there are 26 EU member states which have bilateral investment treaties with China. So, of course, when we will have an EU investment dispute settlement system, then those 26 bilaterally, 25, because there are 2 countries which have one common agreement, so Belgium and Luxembourg, but there are 26 countries, 25 BITs, all of them include ISDS. To my knowledge, ISDS was never used against China by all the companies which are coming from the EU member states which have such agreements. So voila, there is a need of KAI phase 2, and I will take over this expression also if you allow me, because that would be very important. So just to finish, a message from the EPP and also a message from the European Parliament. We have a strong interest on the scrutiny of the investment agreement, which will be going on in the following months. Generally speaking, we have a strong interest, and that already was mentioned last year when we discussed with the trade commissioners, the 2 trade commissioners which came one after the other, that we have interest for monitoring the implementation of all trade agreement. So Denis Redonnet, you will be our Superman also, together with Valdis Dombrovskis, the trade commissioner and vice president of the commission, because we see, and this is my final idea, we see that our monitoring of implementation is in favor, of course, for European industries and European companies, but especially for European SMEs, because we will push you in the European Commission to create more instruments of access for SMEs. Those which you have already presented are wonderful, but always, as we could hear today also, there is room for better and better performance. So thank you very much, and I think this was, and thank you for your contribution. And I think this was our first event in our 2021 China series for the SME Europe of the EPP. Thank you.
Thank you very much, Mr. Winkler. We will definitely take this up. Just to conclude the conclusion, we can see that no matter how simple the question, the answer can be very, very difficult. The efforts for compliance and implementation are not one size fits all. Monitoring and enforcement is key, and the toolbox is wide and currently under development. So just keep an eye out for all the updates. We see that it is not only one actor that is involved. I mean, obviously the Commission, through the Office of the Chief Trade Enforcement Officer, and through the political engagement of the Executive Vice President. This is only one part. The European Parliament, as Mr. Winkler mentioned, through parliamentary diplomacy, will also play a role here. And we must not forget the member states, as well pointed out by Mr. Redonnet. So on behalf of all of us here at SME Europe, thank you very, very much for taking the time today. This was a very fruitful discussion, I think, and good to know that we can keep this going. So thank you very much. Have a good day and stay safe, of course.